Good morning and welcome back to ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Karolina Latasz. I'm a senior associate at 𝗔𝗥𝗕𝗙𝗙 in London and a member of the ARBinBRIEF team. Today, we'll hear from two fantastic arbitrators on the topic of early determination. It is my pleasure to introduce you to Anna-Maria Tamminen and Emilie Gonin. Anna-Maria is a partner at Hans Snellman in Helsinki. She's also a member of the ICC Court of Arbitration, representing Finland, and sits on the SCC Arbitration Institute Board of Directors. Emilie Gonin is a barrister at Bridport Chambers in London. She sits regularly as an arbitrator. In addition to her expertise in commercial and investment treaty arbitration, she's also a public international law and human rights specialist. Today, we discuss early determination. The procedure is certainly not a novelty in the arbitration world. It arguably made its first official appearance in the 2006 exit rules in the investment treaty context. Many of the leading arbitration rules now expressly empower tribunals to issue early determination decisions. The mechanism has also been discussed in the context of Ancestral Working Group 3 ISDS reforms. Yet we are still to see early determination being applied widely in practice. I'm very much looking forward to hearing our speakers break down early determination for us and share their insights from civil and common law perspectives. Let's jump right into it. Emilie, why don't you start us? So what is early determination?
Thank you, Karolina, for the introduction. So early determination is the determination by an arbitral tribunal of unmeritorious claim or defenses at an early stage of the proceedings. It is also sometimes called summary dismissal, because summary dismissal and early determination are effectively the same thing. It's just that the focus is different. While the expression early refers to the timing of the determination, summary dismissal focuses on the procedure itself, in particular the fact that this often takes place without a hearing, or at least without cross-examination of witnesses. Now, Karolina, you've said tribunals haven't used it, and you're quite right. Historically, tribunals have been very cautious about early determination. And that's because they did not want to expose their award to challenges on the basis of lack of due process. In the arbitration context, and again, Karolina, you were right, ICSID was the first institution to introduce an express summary determination procedure in its 2006 rule. And that was following concerns from the parties that the Secretary General's screening power over claims registered were limited to claims manifestly outside the jurisdiction of the centre. And so Rule 41.5 was introduced, and it introduced the ability for the parties, no later than 30 days after the constitution of the tribunal, to file an objection that a claim was manifestly without merit. And it is now in Rule 41 still, but not just 41.5, in the ICSID Arbitration Rule 2022, with further development as to the scope of the remedy. So now the new rule makes it clear that it can concern the substance of the claim, the jurisdiction of the centre, or the competence of the tribunal, and gives more detail as to the procedure. Now, many arbitration rules, and that's a recent evolution, expressly provide for it. So Article 29 of the SAC Rule 2016, Article 22.8 of the LCIA Rules 2020, and even more recently, Article 39 of the SCC Rule 2023. And actually, interestingly, in the SCC rule, it is called summary procedure. And then other institutions have made it clear that the tool is available as part of the tribunal's case management power, but don't provide for it expressly. And that will be the ICC. So it's in the note to the parties and arbitral tribunal on the conduct of the arbitration under the ICC rule. And that's the 2021 note, but it was first introduced in 2017. So it's at paragraph 109 to 114. And then it's also in the Swiss Rules of International Arbitration Practice Note 2023 at paragraph 125. It's a very short paragraph, and it treats it deals with early determination and summary dismissal. It's got both titles, and that confirms the two concepts are the same.
Thank you, Emilie. So let's take another step. And what is the applicable test in investment treaty, and what are the common themes that we can find in the investment treaty tribunal's decisions?
So the investment treaty case law on early determination was first developed in the context of Rule 14.41.5 of the ICSID Arbitration Rule 2006, which referred to the possibility of a party to ask that a claim be dismissed on the basis that it is manifestly without legal merit. So the question is what manifestly without legal merit means. This is a high threshold. It was first discussed by the tribunal in Transglobal versus Jordan, and where the tribunal found that the objection must be established clearly and obviously with relative ease and dispatch. The standard is thus set high, and tribunals have then consistently asserted that the threshold was a high one. So what does it mean? What do they mean by high threshold? They mean that they should not engage with contested facts in their analysis. And the reason is that the rule was designed only to apply to undisputed or generally undisputable rules of law, to uncontested facts. The claim, where claim lacks merit, it's got to be clear and obvious, so manifest, and that's that has to be distinguished from when actually the claim is can be argued one way or the other. And so that's how the tribunals have made a distinction between what's manifestly without merit and what's not. Novel issues of law will also not be determined through this procedure. The burden is to demonstrate that such threshold is met is on the party making the application. And examples of successful application for early determination are good to see what tribunal will typically allow. So for instance, an objection that a limitation period ousted the tribunal's jurisdiction rationale temporis in Ansung versus China was accepted. An objection that a commercial contract did not constitute an investment in Global X versus Ukraine. So it's got to be clear questions of law as we can see.
Thank you so much for this whistle-stop tour. Anna Maria, can we now please move to the early determination and commercial arbitration? Emilie has referred to different rules which use different wording. So what is the standard? Is the standard impacted by the different wording? And is the standard different as between arbitration seats?
Thank you, Karolina, and thank you, Emilie, for setting out both the background as well as actually referring to the rules that I had also looked into. Makes my job a lot easier. But you're right. I mean, different rules use different tests, but actually a lot of the factors seem to be common to many of the rules. So if we look at Article 22 of the LCIA rules for early determination, the arbitral tribunal shall have the power upon the application of a party or upon its own initiative. And I think this is one distinction that we see, that not all rules allow. For example, the SEC rules do not allow upon the tribunal's own initiative, but only upon the application of a party. Then they say, in either case, only after giving the parties a reasonable opportunity to state their views, which seems to obviously be a sort of standard that is also applied in a number of rules or in the context of different rules. Then under the LCA rules, the sort of what I would call the substantive standard seems to be to determine any claim, defense, counterclaim, cross-claim, defense or counterclaim, or defense to cross-claim. So basically all potential claims. And I think this is one where we also see some differences between some of the rules, whereas it seems to be that mostly at the moment, most institutional rules have a broad scope on these. And then on the sort of what the issues are that early determination may concern under the LCA rules, it would be these claims that are manifestly outside the jurisdiction of the arbitral tribunal are inadmissible or manifestly without merit. And this seems to be a standard that is sort of in slightly different wording applies in the context of different institutional rules. Like Emilie pointed out, under the ICC rules, we do not have a specific standard because under the ICC rules, according to the practice note that also Emilie referred to, these are issues that fall under the broader powers of the arbitral tribunal under Article 22. But basically, if we look at the practice note, we would then be saying, or looking at manifestly unmeritorious claims or defenses. So it covers both claims and defenses. And then the sort of substantive standard seems to be manifestly unmeritorious. If we look at the 𝗔𝗥𝗕𝗙 rules, we see the same elements. So manifestly without legal merit, manifestly outside the jurisdiction of the arbitral tribunal, or manifestly inadmissible. And here again, on the procedural side, an application for the early dismissal of a claim or defense, so we have both. And then we have sort of more specifics that they need to be detailed in the application and so on and so forth. The SCC has and like Emilie pointed out, uses a different terminology for the summary procedure. And here, it's a slightly broader definition. A request for summary procedure may concern issues of jurisdiction, admissibility, or the merits. And then there's a list of examples. So it may include an assertion that an allegation of fact or law material to the outcome of the case is manifestly unsustainable. Even if the facts alleged by the other party are assumed to be true, no award could be rendered in favor of that party under the applicable law, or any issue of fact or law material to the outcome of the case is for any other reason unsuitable to be determined by way of summary procedure. So that has a slightly broader set of issues. I think then if we go into the sort of case law that has been decided under these provisions, we see perhaps more similarities than differences.
Thank you so much, Anna Maria. That was a really great summary of the state of the arbitration rules. And then, Emilie, I've got another question for you. Case of commercial arbitration where there is a seat, what if the lex arbitri doesn't vest the tribunal with a power to issue an early determination decision? That's obviously less of an issue in 𝗔𝗥𝗕𝗙, where we don't have the traditional seat, but in commercial arbitration, that will always be a consideration on the tribunal's mind.
Yeah. As long as there's no mandatory rules at the seat preventing early determination, tribunals can make these determinations if the rules allow it expressly or through the practice note. But of course, you're quite right to ask the question, when tribunals are seated in jurisdiction that are not familiar with this type of procedures, they're likely to tread carefully. And that's particularly where the arbitration rule do not expressly allow the same. And that comes down to what we were discussing in the very beginning, which is because arbitration is a consensual procedure, there is a concern about due process and the idea that if the tribunal does not allow due process or decides an issue at a summary level or at without hearing witnesses and without a hearing, the award might be challenged. Now, it's interesting that in England, you will have seen the arbitration bill proposes to add Section 39A to the Arbitration Act 1996, which will explicitly allow tribunals to dismiss a claim on a summary basis. And if you look at the submissions of various law firms or barristers or organizations which supported this amendment, it's precisely to incentivize tribunal to use the tools that they have more. So if one look at the submissions made in favor of such rules, one of the submissions, I think it was the Sherman and Sterling one, said, "Why it is arguable that tribunals already have this power, it is being used less than it could." So the idea is to make tribunals comfortable to use the existing tools.
Thank you very much. So I would now move to the last question, and that is the clash of the legal cultures. Now, early determination will probably be quite familiar to the common law lawyers, and they might be more comfortable with early determination because of the, for example, summary judgment procedure. So it'll be great to hear from you from the civil jurisdiction perspective and from the common law jurisdiction perspective. What are the approaches to early determination? And then also, what are the barriers to early determination being used more broadly? Anna-Maria, would you like to start?
Happy to, as it seems that in most of my arbitrator cases, I seem to be dealing with or a party that comes from a common law jurisdiction, another one from a civil law, and I've seen these clashes in action quite a few times. I think, I mean, for this one, it's a bit the same as any other sort of mechanism that has been copied to or has its origins in sort of common law systems and has made its way into arbitration. And I just participated in a discussion last week in Vienna on use of depositions in the context of arbitration. And I think that some of the elements are similar in that context, or say the use of applications for security for costs, for example. So if you have on the one side counsel who are very familiar with the mechanism, and then on the other side you have counsel who are very unfamiliar with the use, and then depending on exactly where the seat is and what the rules are that are being used, I think the tribunal is also in a position where it needs to do a fair bit of translating between the application and perhaps the response there too. And I think under civil law, it's hard to find, for example, tribunals that would, of their own volition, adopt any of these mechanisms. That obviously you get case law out of cases where you have either common law counsel on one side or both sides, and on the basis of an application of a party. And I think this is, for example, seen if we look at the SEC. There's a note on the use of these procedures in that context, and I think that that reveals that the mechanisms are being used once you have counsel that are familiar with these. I think what you see from a civil law perspective is a very sort of strict adherence to whatever the language of the rule in question is by tribunals, obviously out of some sort of fear that this is going to bite them later on. And I think that's perhaps then also one of the issues that tribunals keep in mind when deciding applications. I think where it's most prevalent in a civil law context that you will find early determination or tribunals being comfortable using this in the context of tribunals deciding early on their own jurisdiction and dismissal of claims that are then sort of manifestly outside the scope of what they can actually decide on the basis of arbitrability under the applicable law, for example.
Thank you. Emilie, what's your take?
Yeah, I cannot speak for all common law jurisdictions, but if you have an English qualified tribunal with English qualified lawyers as parties, you're likely to have a tribunal that is favorable to early determination and summary dismissal, because this remedy are just readily available in the English court. So that is for sure. And I then agree with Anna-Maria, when you have a mix of jurisdiction and a mix of legal culture, which in arbitration is fairly common, if not the rule, that becomes a lot more complicated. And I think we'll discuss the process in practice, but when it's come up in my cases, and it's not come up when I sat as arbitrator, but it's come up as counsel. It depends a lot on the background of the tribunal members, whether or not you make the application. So I think it's very culturally sensitive. And there are cases where it'd be a no-brainer to apply before the English court, and you'd advise your client that you will get summary judgment, and you will not advise your client in the arbitration that they will get summary dismissal or early determination. And I feel there is a cost balance as well in arbitration. So in the sense, when you advise your client and you're not sure what way it's going to go, because it's all a bit wobbly and depends on the culture of the tribunal. If you're not sure, it might be taken into account by telling them, well, will you really want to waste costs on this? That I feel is one of the broader problems as to why it's not used more widely as well.
Absolutely, thank you. And probably just another issue to bear in mind when constituting a tribunal, and if you're faced with a case when you think is very weak from the opponent's side, that you may want to consider the constitution of the tribunal and their background accordingly. Thank you so much again. Our webinar unfortunately ends here, but fear not, we will continue our discussion in a Q&A session, and a link has been posted in the chat box. And we will be back in 2 weeks with Elizabeth Chan moderating an episode on arbitrators' technological competence. So make sure you sign up on our LinkedIn page. Finally, we would like to say a big thank you to our supporting organizations, including the Lagos Chamber of Commerce and the Equal Representation Pledge in Arbitration.